Hi दोस्तों नमस्कार. Welcome to our YouTube channel Bajirao IAS Academy. Today is 2nd of November and we are going to discuss the daily Hindu newspaper analysis. So today we have three articles in discussion, and the first article is related to artificial intelligence and the issue of the copyright. When we talk about artificial intelligence, what does it mean? It means you are giving the thinking power to the machine. And what happens when you give the thinking power to the machines? Actually, they start doing the creative work. They will ease your work. But there comes with a challenge. What is the challenge? Now the world is recognizing that challenge. Like when we give the machines the creative work to be done, that means who will be the owner of that creative work? Whether the artificial intelligence or the owner of the asset or the owner of the machine. That is a issue. Okay. And suppose I will take an example, like we take an example of chat gpt, and I commanded to the chat gpt that please make a song for me, please make a creative poetry for me. They will find the sources from the internet, the data from the internet that is available, okay, like from the news source, like from the author of a book, okay, like the novels or the journals, and they will try to create a poetry for me. But remember that these poetry is actually the outcome of the data which was available in the internet. So that means what? Even this artificial intelligence didn't created the creative work from their own self, but they had actually analyzed the data, summarized the data, and then created the work. Okay, so that means there is a chance of copyright violation, because actually the data comes from the internet and the artificial intelligence or the machine learning are utilizing that data. Okay, so is there is a violation of copyright? Well, the world is trying to say yes. Okay, and that's why like US and other countries are concerned about this issue, copyright issue. Okay, and we will be dealing a case associated with this as well. So hope I overviewed the basics about the topic, and hope we are going to understand in a great detail. Okay, and the second article is related to the blueprint to develop India by 2047. Recently our prime minister said that he is going to unveil the blueprint of India, and in this blueprint there will be a mention of the roadmap that India is going to be a developed nation by 2047. So what needs to be done? Some of the suggestions has been given by this article, okay, to be implemented. Okay, so that is the point. And the third article is related to women's freedom to reproductive choice. So this is also very good article, and here we will be discussing the basics from, and we will be going to advance as well. Okay, so let's start our discussion. But before that, we have a prelims question for you to solve, and the question is related to the polity section. Okay, and these type of questions is frequently asked by the UPSC, and the topic is related to parliament. Okay, so when we talk about the question, consider the following statements. Statement 1: the Parliament of India can place a particular law in the ninth schedule of the Constitution of India. The second statement: the validity of a law placed in the ninth schedule cannot be examined by any court and no judgment can be made on it. And you have to choose the correct statement. Okay, option 1, option 2, option 3, and option 4. So here you have to focus on the ninth schedule. Okay, and I think we have discussed about the ninth schedule, and yesterday's lecture I have discussed about the 10th schedule. Okay, and I had given you a question also, so maybe you have solved it, and try to solve this question. Otherwise we will be providing the answer to this question during the last session of our discussion. Okay, so you can comment your answer in our chat box, and we will be replying to that as well. Okay, so friends, let's start our discussion. And the first article is related to the GS paper 3, and you can link with the technology section. Okay, artificial intelligence. So when we talk about artificial intelligence, You can see the picture. Okay, this is a man and this is the machine, and they are talking to one another. Okay, but the machines are talking in an like thinking as well as replying. What I am trying to say, that machine has been given the thinking power with the introduction of artificial intelligence. Intelligence means what? Thinking. Okay, so thinking means what? Just like you have a thinking, you have a brain, so you can do a creative work, you can analyze a data, you can compose a music, write a book, and do many things. Okay, similarly, when we are entering into the field of artificial intelligence, that means the machine can also do the work. But the issue the world is facing and can be faced in the future is about the copyright issue. Okay, like we have told you that I have given a command to the chat GPT to make a story, to make a creative story. But the chat GPT will create a story from where? From the data which is available on the internet. Okay. But the data is coming from where? From the books, from the novels that are available digitally, that are published by the author, that are published by the novels. Okay. So that is the point. So there can be a issue of violation of the copyrights. So who will be responsible? Okay. So these all are the concerns that has been highlighted in this article, and here we will be also discussing about the India's perspective and India related concerns. Okay. So first of all, the context is executive order in the United States issued by the Biden administration on October 30 on safe, secure, and trustworthy artificial intelligence. And what these are like executive order indicates, like we are promoting towards artificial intelligence, but that should be safe, secure, and trustworthy. Okay, so that means we are having a changing attitude towards the artificial intelligence regulation, because you know that any technology has its own pros and cons. So initially we were talking about the positive benefits, okay, but we were ignoring the negative aspects of it. But now, as the role of artificial intelligence is increasing, there is a necessity that artificial intelligence should come with necessary safeguards. Okay, otherwise there can be an enormous implications. Okay, and for here to understand, I can remember that you can watch the movie Robot if you hadn't watched. Okay, so that will give you a perspective about the negative repercussions a machine having the thinking power can create. Okay, so that is the point. And when we talk about the issue, okay, so the issue is about ownership and enforcement. Like with the introduction of artificial intelligence, there is a tough questions in ownership and enforcement of the intellectual property rights. I have given you the example of chat GPT, okay, and another language model like Midjourney. Okay, and basically the answer given by these tools is basically from the data from the internet. Okay, so that means they can infringe the rights of millions of the authors and the artists on the internet. Okay, so who will be responsible? The point is that, okay, and the world leader are silent on these issue, but the concerns are increasing. Okay, so when we talk about a recent example, and you can like understand this example, and you can also compare the decision taken by the United States District Court and the decision taken by the Indian Copyright Office, and the comparison, okay, regarding the author of a creative work done by a machine, okay, or the artificial intelligence. So basically, United States District Court for the District of Columbia, in the case Stephen Thaler versus Shira Perlmutter, gave remarkable judgment. Okay, when we talk about this case, so you can understand that a person called Stephen Thaler, they owned an artificial intelligence system, and the machine name was Creativity Machine. Okay, and via this machine they created visual art. Okay, and After creation of this visual art, they went to the copyright office to file an application for the copyright, okay, before the US Copyright Office. And in this application, the creativity machine was mentioned as the author of the work, okay, not the person, but the creativity machine, okay. So the application was given to the copyright office, and the author was named to be as creativity machine. But the copyright office of the US rejected the application because they simply said that this creative work lacks the human authorship, okay. This is not the creative work of human, and we does not recognize, not we do not recognize the non-human, okay. So the court concluded that human creativity was essential to copyright protection. That is the important point. And that was given by whom? The US District Court. But when we talk about in case of India, similar incident were visualized in India as well. But when we talk about India's Copyright Office, so they they approved the application, okay. But here they didn't reject it, and in place of the rejection they listed the artificial intelligence machine as the co-author, okay. I am trying to give you the perspective. In 2020, the Indian Copyright Office registered a work of art called Suryast, okay. And in this creation, the artificial intelligence machine did help the person, and the name of the machine was Raghav Artificial Intelligence Painting App, okay. So this artificial intelligence helped to create the art, okay, creative art. So when this person visited to the Indian Copyright Office for the registration, okay, so first of all the Copyright Office rejected because in the first instance the person declared this artificial intelligence as the author. I am talking about as the author, okay, not the co-author. But in the second instance, when the same person visited to the Copyright Office and mentioned the this machine as co-author, that was given the approval, okay. So what we are concluding, that in US we are saying, we are observing that the non-humans are basically rejected, okay, in terms of getting recognition as author or the co-author. But in India we are seeing that the co-author was approved, okay. So we can say that Copyright Office in India ignored the human authorship requirement in the Indian copyright law, as we have seen in the US case, okay. So that is the point. And there are also concerns regarding this. First of all, the Copyright Office is also yet to articulate mandatory disclosure requirements on the use of artificial intelligence, okay. And when we talk about recommendation of 161st report of the department related parliamentary standing committee on commerce, so basically they suggested that the Copyright Act 1957, which is very much old, and also the Patent Act 1970, to incorporate the emerging technology of artificial intelligence and artificial intelligence related inventions into their ambit. That means the government is also trying to integrate these emerging technology, okay. And what will be the repercussions, there can be the relaxation to the standards for securing the copyright and patents. And what I am trying to say here, that if India do recognize these type of emerging technology in the copyright, that means they can challenge the traditional authors, okay. They can also have a negative implications on the startup ecosystem in India, okay, because these are the machines, okay. So they can generate work, they can create presentation, they can create some artistic work in a very short period of time, okay. But when we talk about the humans, they require time and they require incentives, okay. So maybe if machines are being integrated into the world of creative art or creative and innovative work. That means there is a need to have a proper regulation on that. Okay, so that is the point. And when we talk about conclusion, so first thing that when we talk about intellectual property rights, so whenever intellectual property rights are given to an object, okay, to a creative work, that means the person, the owner, have a exclusive right to use, to distribute, okay, and there can be a negative repercussions of this monopoly protection, okay, because the society, the vulnerable society, the weaker society may not be able to utilize that asset, the resource, okay. So there is a need to be cautious about extending the emerging technology like artificial intelligence and all of that, okay, and giving recognition as co-author or author, okay. So there is a need to have a proper analysis, understanding, okay, before doing a straightforward approval. So that is the point. And when we talk about conclusion, so policymakers or courts in India also need to assume a more cautious approach against the diluting human centricity in copyright law. Till we have seen that in any copyright law, the human creativity is supreme. Okay, but with the introduction of artificial intelligence, this can affect the human centricity, but we need to place the human centricity above all. So that is the conclusion of this article. Hope you understood. Now we are shifting to the second article, and second article is related to GS paper 3. And when we talk about the blueprint of India by 2047. So when we talk about India's independence, so in 1947, India got its independence, okay, and that is a huge achievement for India, okay, because before that, India was a colonized country under the influence of British, okay. So there was no independency in taking decisions, whether it is political, whether it is economic or social, and we see the harsh reality of the problems faced by our citizens, okay. So that is the point. But when we talk about the status of India at a current level, so India is still a developing nation, despite we have 75 years of independence already went out. Okay, so do we need to have a situation like this? And also, we are seeing various issues like hunger, poverty, malnutrition, and all of that. So there is a need to have a improvement over that. Okay, there is a need that we should move forward from developing nation to developed nation, and to be in that scenario, there is a need to have a proper goals and ambitions, okay, and ambitions in terms of various field, whether it is social field, whether it is economic field, whether it is sports field, and all of that, okay. So there is a need to have blueprint. So in the coming month, specifically January 2024, our prime minister is going to release a blueprint of India 2047, and in this blueprint there will be a target, aspirations, goals to make India a developed nation by 2047, that is after 100 years of independence, okay. And that is a good point. And remember, when we talk about any goals, let's say you set a goal, you set an aspiration, and if you start working on that, there may be chances that you can get it cleared, okay. So the importance of goal is very high. And in this preparation of the roadmap, the Niti Aayog is basically making the collaborations. They are inviting the various stakeholders like industrialists, business, and the technology experts, all of that, because this all requires bigger dimensions, okay, and discussion, deliberations to come to the important goals and targets, okay. But when we talk about these documents, okay, so whether these will be a document only or document with action, so you will say that there is a need to have a document with action, yes, Whenever these type of document get released, that means the government or the coming government will try to focus on these goals to achieve. Okay, without any goal means you are directionless. Okay, but if you have a goal, if you have a blueprint, then you can work on that. Maybe the time will be longer, but you can work slowly and you can achieve that. Okay. Sorry. And when we try to compare with respect to the previous history, okay, so when we talk about India's rise from 1991 onwards, when it accounted for 1.1% of the global economic output to 3.5% share. When we talk about 3.5% share, it means like a global GDP, and our contribution is 3.5%. Okay, and in 1991 it was 1.1%, so that was very less, and now we are increasing. So that was a sudden change from the shift of our policy. What was the reforms taken that time? LPG reforms, liberalization, okay, globalization, okay, these all the reforms were taken. And for that there was proper blueprint prepared, and then it was executed. So it was compared with this upcoming document 2047, okay, roadmap. So that is the point. And there are some suggestions which are providing in this article, like the policy should always aim for ensuring certainty for the global investors, because when we talk about global investor, they try to think many more times before investing. So if the certainty in policy, regulations, economic laws are there, that means they are going to invest here. Okay. And along with minimizing the government's role, we say now, like minimum government, maximum governance. So this principle should be adopted, and government should be an enabler rather than a micromanager. Okay. And we have the initiative that reflects minimum government, maximum governance, like production linked incentive, okay, import licensing, or overtly zealous taxation, like ending the taxation system of the past. And we have introduced GST, okay, goods and service tax, that aims for one nation one tax, okay, and one nation one tax. So that is the point. And here there is a challenge of middle income trap, and that needs to be addressed. You need to focus on the middle income trap. And what do you mean by middle income trap? You see that India's GDP is rising, okay, India's GDP is rising, and with increase in GDP, there should be rise in the income level, okay, there should be rise in the growth of the income of the farmers, workers, daily workers, all of that. But what we are seeing, the income growth is very much less. People's income are trapped. Okay, despite we have the GDP growth and all of that. So that is the middle income trap, and it needs to be ended. But this concept of middle trap, you can understand, was given by economists, and there is a very effort needed to come out from this, because many of the developing nation is facing the middle income trap. Once upon a time they rised very fastly, but when we talk about the reduction in income inequality, that is not reducing, okay. And also we have to address the income inequality, okay. So that means what we are trying to like bring reforms to make India as a developed nation by 2047. The goals, the targets should be dynamic in nature, so that we can adjust as per the situations, the issues that may arise in the coming future, okay, to recalibrate goals based on evolving global trends. For example, when we talk about artificial intelligence, so in the coming time, the artificial intelligence will be becoming a major breakthrough, okay, and almost every sector will be integrating artificial intelligence. So here the government's goal should focus on these these sectors, okay. So that is basically means dynamicity nature, okay. And also be ready for the black swan events. For the prelims, I am explaining you about the black swan event. So basically, black swan event is like an unpredictable event that may occur instantaneously without any sudden information, without any prior information. Okay, and that situation has the potential to cause severe consequence. And you can take the example like the COVID-19. You can also refer it as black swan event. It was unprecedented, it was unpredictable, and that caused huge damage. Okay, sometimes you can see about the global financial crisis. Okay, or even let's say we talk about like the war. Okay, sudden war escalation. So that can also be referred as black swan event because these are unpredictable event. Okay, we cannot predict, and suddenly they can come and they can damage our like various resource, various assets, and many things. So that are black swan event. Now we are shifting to the next article. Hope you understood the previous article, and this article is also very important, and it is related to GS paper 2. Okay, and here it talks about the woman's freedom to reproductive choice. Okay, when we talk about the woman's freedom to reproductive choice, it simply means women should have freedom to decide whether she want pregnancy or not, whether she want termination of pregnancy or not. Okay, so that is the point. And why I am highlighting this issue, because there is a case which went to the Supreme Court. Okay, and we are trying to elaborate on that case. First of all, you understand. Okay, on October 16, in X versus Union of India case, here X represent the name of the woman, and for the privacy concerns, that's why it has been said out. Okay, so the Supreme Court of India declined permission to a woman who was seeking to terminate 26-week long pregnancy. And why Supreme Court declined? It was all because of the Medical Termination of Pregnancy Act 1971, because this act gives 24 weeks of time to terminate the pregnancy. If more than 24 weeks goes, that means there is a need to have a verification that there is a special case, okay, to terminate the pregnancy. So that's why on this ground, the Supreme Court, headed by the Chief Justice of India, declined. Okay. So when we talk about the basics of Medical Termination of Pregnancy Amendment Act 2021, here you have to compare. Okay, because after a long time, this amendment was done. So to understand the issue, to understand the article, there is a need to understand this basics of the act. Okay. So when we talk about the MTP Act 1971, so initially they were only applied to married women. Now they are applied to unmarried women also. Okay, and in the MTP Amendment Act 2021, women had the freedom to decide the termination of pregnancy basically within 24 weeks. But beyond 24 weeks, uh, substantial fetal abnormalities like conditions should be verified. Okay, otherwise the termination of pregnancy will not be allowed. Okay, so that is the point. And when we talk about the role of medical practitioner, so if the pregnancy period is within 20 weeks, that means one registered medical practitioner's approval is needed. And if it is between 20 to 24 weeks, that means two registered medical practitioners approval is needed. Okay, but if the termination of pregnancy is beyond after 24 weeks, that means medical board approval is needed, and there is a condition here. Okay, and we will be discussing the condition. So that is the point. And for understanding the article, you need to understand that in normal scenario we have 24 weeks, and let's say if there is a abnormality, okay, So that requires the approval from the medical board, and along with there is a certain conditions. Okay, like if there is a threat to the life of woman. Okay, and if the child, if the upcoming child will face great abnormalities and all of that, these are the exceptions. Okay, then the termination of pregnancy will be allowed after 24 weeks as well. So that is the point. And but here you can see that in the judgment, the Supreme Court rejected, okay, based on the fact that the fetus was viable. Viable means in good condition and there is no issue to the like mother's health. So that was the ground. Okay. So here the article talks about the against judgment. Okay, and here there is a debate between a viable fetus versus woman's right. Okay, so viable fetus means that the children will be able to develop well, and this is the scenario. And here in this case, woman basically get to know about her pregnancy only after 20 weeks. Okay, and when they did the ultrasound, okay, that came to the conclusion that the fetus is actually more than 24 weeks. Okay, so that was the issue, and due to that the case went to the Supreme Court, but Supreme Court directly rejected because the mother's health is good, and the fetus is in viable condition. Okay, and here the judgment only focus about viable fetus. Okay, but not about the woman's right to choose. Okay, bearing the circumstances that we have talked to you in the exceptions. So the judgment suffers from at least two errors. First, a right of pregnant woman to her privacy and dignity was compromised as compared to the right of the fetus. And remember that when a child is in the fetus, okay, there is no constitutional right given to the fetus, because the constitutional right are allocated to the persons. Okay, and person is that who is basically living on the earth. Okay, who have come in the earth, not within the womb. Okay, so that is the point. So here the right of the pregnant woman to her privacy and dignity was compromised. Okay, and remember the Putteswamy judgment. Okay, what the judgment talk about? Right to privacy is a fundamental right. Okay, and also right to dignity. So that is the first point. And when we talk about MTP Act, based on which the Supreme Court had given the judgment by following the rule of exceptions. Okay, so basically these are enabling legislation. Okay, and what is the aim of this legislation? That they aims to protect the reproductive rights of a woman. Okay, the reproductive rights of a woman, the woman's decision to like carry the baby or not. Okay, so that is the point. But here the court did opposite to it. Okay, and the petitioner's plea and rulings was not accepted, and two pleas were given by the woman, like she was suffering from the postpartum depression, and also her husband was only earning member of the family, and they cannot ill afford to care for a third child. So these were the players, but Supreme Court said that these player is not fitting in the exceptions that are provided in the MTP Act. Okay, so that's why the judgment was given like that. So some other issues can be highlighted here, like these are against fundamental rights to privacy, okay, and dignity. And when we talk about this fundamental right to privacy and dignity, so that enabled individuals to exercise autonomy over their body and mind, and allowed women complete freedom to make the reproductive choice. Reproductive choice means what? The choice of woman, independent choice to decide whether she want to have a child or not. Okay, she want to like terminate their pregnancy or not. These comes under reproductive choice. Okay, so that is the point. And when we talk about the fetus and the rights, okay, so the judgment implicitly try to understand this statement. The judgment which has been given by the Supreme Court indirectly asserts that fetus have constitutional right. But when we talk about our constitution, so our constitution gives the fundamental right to whom? To a person. And a person basically comes out from the fetus and actually they are living on the earth. Okay. So that is the point. And when we talk about abortion, okay, so abortion, it talks about termination of pregnancy. So there is conflicting viewpoints here. Okay, so the guarantees of the constitution given under article 14 and 21 of the constitution, okay, that is the right to equal protection and life, are conferred on persons, and constitution decidedly does not about personhood to a fetus. So this is very important. And when we talk about the fetus, so basically they are dependent on the mother. If mother decides to carry forward the child, that means they will help in the better collaboration and the emotional relations between mother and the child. Okay, and if mother are not ready, that it will affect both mother and the child as well. Okay, so that's why uh seeing fetus and mother as a separate, as a distinct personality would be tantamount to conferring a set of rights on it that our constitution provides only to a person, not to a fetus. Okay, so that is the point. That is the end of the article. Hope you understood. And now we have the prelims question. Okay, and the answer is option A, one only. Why? You can read the statement. The Parliament of India can place a particular law in the ninth schedule of the Constitution of India. Remember that Parliament has enormous power, first of all, to legislate. Okay, so the ninth schedule is basically what? A type of legislation. So they can do this. First of all, we will be discussing about ninth schedule. Ninth schedule basically talks about the land reforms, and it was inserted into our constitution via first constitutional amendment act. Okay, and that time, you know that there was a system of jamindari and there was huge concentration of land and wealth to a smaller people. Okay, the prosperous people, and because of that there was inequality in land holdings. Okay, and because of that there was poverty and other associated challenge, income asymmetry and all of that, and to deal with the land reforms was carried forward. Okay, so that is the point. And when we talk about the second statement, the validity of a law placed in the ninth schedule cannot be examined by any court and no judgment can be made on it. No, initially this was the thing, but after a ruling from the Supreme Court, the matter which is placed in the ninth schedule after a due date, that can be examined by the Supreme Court as well. That's why Supreme Court has said regarding this that Supreme Court, matlab the Parliament cannot put a blanket ban on the ninth schedule. Okay, so that means this is wrong. Here, the judicial review can be done. Tell me the case where Supreme Court talked about the ninth schedule as blanket ban. Okay, blanket immunity. And that is the end of the article. Hope you enjoyed. Thank you, friends. Thank you. And you have the schedules, you can remember. Okay, and we have a short code, tiers of old PM. And here tiers stand for territories and states, E stands for emoluments, A stands for affirmation and oath, okay, R for Rajya Sabha seat and location, and you can remember in the short form. And here it is the ninth schedule that deals with the land reform. 10th schedule we have discussed in the article that deals with defection. Okay, it was inserted via 52nd amendment Okay, in 1985, and we have the last schedule as municipalities, which was inserted via 74th constitutional amendment. So friends, that is the end of the article. Hope you enjoyed. Thank you very much. We will meet again in the next series. Thank you.